Good evening, everyone. The Hampton Bays Public Library would like to welcome you to Estate Planning Basics with Britt Burner. I'm going to read a little bio of Britt so you can be a little more familiar with who she is and what she's done. Britt Burner is an attorney at Burner Law Group, PC, a boutique law firm handling all matters of elder law, estate planning, trust and estate administration, and special needs planning. Britt recently completed a 3-year term as chair of the New York City Bar Association Committee on the Legal Problems of the Aging. She serves as treasurer of the Elder Law and Special Needs Planning section of the New York State Bar Association. She has previously served as co-chair of the Legislation Committee, vice chair of the Medicaid Committee, and production editor of the section's journal. She is also a member of the New York State Bar Association in the Trust and Estates section. Britt also serves as a member of the Advisory Council of the Katz Institute for Women's Health at Northwell. Welcome, everyone, tonight, and thank you again, Britt, for joining us and putting this wonderful presentation together.
Thank you, my pleasure. Thank you to the library in Hampton Bays for having us and for bringing this important topic to everybody. A little housekeeping. So at the bottom of your screen, you'll see there's a Q&A section. So you can type in a question there and I'll take questions. I think I'm gonna hold them till the end because it's easier when I'm trying to read them myself to do it that way. And that is how you can write in any questions that you have for me. I am going to go through the basics of estate planning and Medicaid. I'll say each of these topics could probably be their own, full day course, if not longer. And so we're going to be doing kind of a broad overview of the topics. And I'm happy to just get going. But thank you again to the Hampton Bays Library, and thank you to all of you for joining us on this Thursday night, sorry. So I'm gonna start with the basics of estate planning. There's some very simple documents that it's very important that you have for your estate planning. I would say we always talk about what we call advanced directives, powers of attorney, and then either a last will and testament, a trust, or both. And we're gonna talk about each of these documents and how you might decide if and what you need of these documents. First is the healthcare proxy. This is one of the advanced directives because you are signing them in advance of needing it. A healthcare proxy says who will make medical decisions for you if you are unable to make them by yourself because you've been determined incapacitated by a doctor. So the document requires 2 witnesses over the age of 18. It can be anybody that isn't somebody who's named in the document. It needs to name one person at a time. So you're not going to have multiple healthcare proxies serving together. They will serve in succession, one after another. An important thing to make sure you're putting in your healthcare proxy document is that your agent knows your wishes regarding artificial nutrition and hydration so that your agent can be allowed to make those decisions on your behalf. Now I'm going to give you an example. I said that this document is in effect if you're deemed incapacitated by a doctor. So take the person who is in the doctor's office and they have their appointment and they talk to the doctor about everything that's going on, and they go home and they talk to their daughter, and their daughter is the named healthcare agent under the healthcare proxy. And the daughter says, well, what happened with the doctor? And they have a conversation, and the daughter decides she wants more information from the doctor because the parent didn't quite report it to her in the detail she wanted it in. So she calls the doctor's office and she says, I would like information. My parent was in there earlier today and I would like information about their medical condition. And the doctor's office says, well, we can't speak with you. And she says, well, I am the healthcare agent under a valid healthcare proxy. The doctor's office in that circumstance is most likely going to say, we still can't speak with you because while that document may be valid, your parent has not been deemed incapacitated. Your parent was able to get themselves here to talk to the doctor, to make decisions. And so if your parent wants you to have further information or communication with the physician, then your parent is going to have to sign a HIPAA waiver, and that is a waiver of the privacy over his or her medical information in order for the doctor to be able to give you information directly. Otherwise, everything is going to have to go through the parent. So it's very important to remember that that healthcare proxy is only going to be in effect in the case of incapacity. The next document I'll review is a living will. A living will is another advanced directive, and it's a document that speaks in very broad terms because it is signed in advance of one needing it. So we don't know who your doctors will be, what your illness will be, what medications and treatments will be available, how old you'll be when this is actually coming into play, and all of those factors are going to change decisions. But it is a general statement of whether or not you would want to be kept alive by certain artificial means if you were determined by a doctor to be in an irreversible state with no reasonable expectation of recovery. So many people know that they don't want a feeding tube. They don't want to be on certain other life support measures. They know that if they're in an irreversible state that they would want to be put on palliative care to be kept comfortable. They might not want all of the cardiopulmonary resuscitation because that can injure somebody in their ribs, or they don't want certain cancer treatments if they're beyond saving, or dialysis treatments. And so this can all go in that document. I often think back to the case in Florida of the young woman, Terry Schiavo, who her parents said she would want to be kept alive in a persistent vegetative state with the hope of getting better. And her spouse said, no, she would not want to be kept alive that way. And without that general written instruction by her of what she would want, this went through the courts, as you all remember, for a very long time because we didn't know what she wanted because it wasn't written down. And so in addition to telling your agent under your healthcare proxy your wishes regarding these things, you also want to put as much as you can in writing to make sure that they have what they need in order to keep acting. Now, there's another form that's often signed, and this is actually signed with a doctor, and it is actually a physician's order, similar to how a do not resuscitate order is a physician's order. That's not something you're going to do with your attorney. It's called a MOLST form. MOLST, Medical Orders of Life-Sustaining Treatment. And that's something that a physician can go over with their patient when somebody's later in life or has a specific diagnosis that says when they would like to be brought to the hospital, when they would not like to be brought to the hospital, and in what circumstances they would or would not want certain treatments. And this is a really important form for those who are aging at home and they want to make sure that if 911 is called, that their wishes are followed. And then this document would follow them to the hospital, perhaps to a rehabilitation facility if that's where they had to go next. And so that's a really important document, again, but you would do that with your physician, not with your attorney. The next document I'll talk about is the power of attorney. Power of attorney is talking about your financial affairs, whereas the other documents I was referring to are talking about your healthcare matters. So for your financial affairs, your power of attorney document says who can step in your shoes and handle your finances. Now, the agent that you name under your power of attorney only has the powers that you expressly give to them. So you may have seen a power of attorney document and there's a list of powers and they have brackets next to it where you can put your initials. They also have a catch-all at the end that says, I give all the above listed powers. But it's very important to realize that if you are letting your agent access your funds, you are letting them do so in all circumstances. In New York State, it's very rare nowadays to see what we call a springing power of attorney, a power of attorney that only is in effect in incapacity, because we found that it's very difficult to have a power of attorney that is based upon a doctor finding you to be incapacitated, because there's a lot of gray area of incapacity. And so a lot of times people want assistance of their power of attorney, but they're not necessarily at a point where they would be deemed incapacitated by a doctor or even by a court of law. And so that power of attorney document is going to be very important. Now, right now, we're in a situation where the last time the power of attorney law was changed was in 2010. If you have a power of attorney from before 2010, you should definitely have it redone. Now, it doesn't mean that the power of attorneys from before 2010 are no longer valid. They are valid as long as they were valid when you signed it back then. But the way that the statute changed was that it put many more powers expressly into the document. And those older documents do not have the breadth of powers that the new one does. And you want to make sure that if you're giving your agent full authority to act on your behalf, that you're actually giving them full authority. We often are in a position where somebody's trying to move around assets for an elderly loved one, and perhaps it's for Medicaid planning, move assets to a trust, gift out of their estate. And in the end, that old document says that gifts can only be made up to the annual gift exclusion amount, which right now is $15,000 a year. Although back when many people signed it, it was $10,000 or $13,000. And so that limits some of the planning that can be done. So if you have one of those power of attorneys from before 2010, you're certainly going to want to redo it. Now, the reason we're in an interesting situation now is because on December 15th of just this past December 15th, 2020, the New York State Legislature had passed, and on December 15th, the governor signed a new law regarding the power of attorney. So it amends the general obligations law so that the power of attorney is going to change again. It is meant to be simpler. It's meant to be easier. It's meant to create a document and a process that's a lot more user-friendly. And that was the purpose for the change. Now, while this law was signed by the governor in December, it will not take effect until June of 2021, so this coming June. We don't recommend that you change your power of attorney to comply with the new law at this time, because one, we believe there'll be some amendments to that law in this time period, and two, you don't want to be signing new powers of attorney before that implementation date. So if you are working with an attorney now to do your estate plan, it's perfectly fine that you sign the current power of attorney, which is in compliance with that 2010 law. Now, if somebody comes to me in July, August, September, after the implementation, I am unlikely to tell them that a power of attorney that I did for them in this time period since that 2010 change needs to be amended. As long as it was a valid and robust power of attorney that was signed in that time period, I believe it will still be in effect. Now, that doesn't mean that 5 years down the line, when all the banks and all the institutions are used to the new form, that we won't recommend that the form be updated for individuals, because we know a lot of the issues with power of attorney is getting it to be accepted by banking institutions. And we often go with the path of least resistance. What is going to make things easiest on you and on the people that you're naming to act on your behalf? The new law also puts a little more stringent requirements on these institutions, that they have to have a certain standard of belief that this is not a valid power of attorney in order to turn it away. The hope is that that will happen a lot less with this change in the law. The next document I'm going to discuss is a last will and testament. So a last will and testament, which most people shorten and call their will, is a document that says what you want done with your assets at the time of your death, who will be in charge of collecting and distributing them, and to whom or what entities they will be distributed. So I name an executor of my will. My executor is in charge of collecting my assets and distributing them to my various beneficiaries. And the way in which I want them distributed. Will they go outright? Will they go in a trust? What are the terms of that trust? All is within that last will and testament document. Now, a very important concept to understand is that your last will and testament, in order for it to be actually dealt with and for it to be a document that is legally binding, it must go through probate. It's a very common misconception that the will does not, having a will makes it so you don't have to go through probate. They actually go hand in hand. You can't have probate without a will document. And if you have a will document, it must go through probate to be followed. So that's a very base piece of information That's very important to understand. Now, assets go through the process of probate when you have assets in your sole name with no beneficiary. So I'll give you a list of a few different types of assets, and we'll talk about whether or not they're probate assets or non-probate assets. So for my example, let's assume that I've given, my will says that all of my assets go to the Hampton Bays Library upon my death. So I have a charity, I'm benefiting that charity in my will. Now I own my home and I own that jointly with my spouse. And I have a bank account that it has $5,000 in it, and that's just in my name. It's where my Social Security and my pension get deposited. And then I have a retirement account, and that names my daughter as beneficiary. In that scenario, the only asset that is going to go to the Hampton Bays Library through the probate of my will is going to be my bank account that gets my Social Security and my pension. Because my retirement account is going to go to my daughter, who I've named as beneficiary. My home is going to go to my spouse, who owns it jointly with me. And so when you're creating your will and when you're creating your estate plan, it's very important to look at who your various beneficiaries are and make sure that your assets are titled properly, either with a joint owner, sole ownership, or beneficiary, to follow your wishes. So sometimes people say to me, should I name a beneficiary or shouldn't I on a specific asset? And the answer is, it depends on what your goals are and what your plan is. It depends on what your assets are. Do you have assets where we anticipate there's going to be estate taxes at death? Is there a benefit to having the assets all pass through your will? Or is there a problem with that? And that's something that you should be discussing with your attorney when you're coming up with your estate plan, to make sure that the planning that you have makes sense. Now, the probate process is a process by which the nominated executor, the person that you have nominated to serve as executor, usually hires an attorney, although they don't have to. And there's probate petitions that are filled out, and they list certain things, including who your next of kin are. So take my same example where all of my assets are going to the Hampton Bays Library in my will. Even though all of the assets in my will are going to that entity, my will still needs to be served upon, and the probate process has to be completed, which includes giving my spouse that I referred to and my daughter that I referred to and any other children that I may have a copy of that will and a notice of probate, and the ability to either sign off and say, yes, we agree, or to come into court and to contest that will and say that that will is not valid for whatever reason they believe that will is not valid. So if you're disinheriting, say, I left everything to the library, my spouse, and my daughter. What if I had a son who I didn't leave anything to? Maybe he's going to be upset about that. So I may not want my will to go through probate, because I may want to avoid him having notice and the ability to come in and contest. Maybe I own not just my house here, but maybe I own a house in Vermont. And if that house in Vermont is in my sole name, well, then my will has to be probated here and it has to be probated in Vermont. So in two places, and that's going to take a long time and it's going to be expensive. Maybe I don't want to go through that, or I don't want my executor, my beneficiaries to go through that. Or perhaps I have a disabled beneficiary, and I believe that the court process of probate is going to be elongated by the fact that the court might appoint a guardian to represent the interest of my disabled beneficiary. These are all reasons why you might want to avoid probate. My favorite reason why you might want to avoid probate, because it brings up my best story, is that you might want to avoid probate if you don't know who your next of kin are. So many people come into me and they say, I am doing my will, but I promise you it's going to be so simple. I don't have any family. I have a lot of friends, but I don't have any family. That is the number one reason why I don't like people to go through the probate process. Why? The process requires that you give notice to next of kin. So I tell them that, and they always say to me, well, I don't have next of kin. Everyone has next of kin. You might not know who they are. You might not be able to find them, but you have them. We had two people who came to see us several years ago now, and we did not do the will. We didn't represent their friend, but they came to us after their friend died. They were the co-executors and the co-beneficiaries of his will. And they said, here's the will. We need to probate it. We want to get the assets. It's a brokerage account. It's about $500,000. How do we get the account in our hands? It's ours now. We are named in the will. We get everything. The account was in his name. So we said, okay, we have to go through the probate process. Who was next of kin? I said, we don't know. I said, okay, let's do a family tree. Was he was in his 90s. So was he married? No. Did he have children? No. His parents were obviously deceased. Does he have siblings? Nope, only child. Okay, then his parents, who were his parents' siblings? I don't know. One parent was from Egypt and the other was from France, and they came over to the United States, I think sometime in the 40s. I think he told us one time, but I don't really know. And in order to probate that will, and in order to collect that one asset and distribute it to these two people, we were forced by the court to do due diligence to attempt to find the next of kin, which presumably were at the first cousin level. We had to hire a genealogist who does work internationally because that was likely to be where the people were. We had to satisfy the court that we looked and we could not find these people. We then had to publish death notices in certain newspapers that the court told us we had to publish in. And many hours, many dollars, and many months, and I think actually about 2 years later, we actually got the will admitted to probate with the court. The court was satisfied that we looked for these people and we couldn't find them, and the asset could be collected by them and distributed. Now, in that situation, that gentleman could have done a few different things, but probably the easiest would have just been to name his two friends as the transfer on death beneficiaries on that account. And then upon his death, they would have furnished a death certificate and some signed forms to the brokerage house that had the account, and they would have gotten a distribution of the account. So it's very important when you meet with an attorney to do your will and to create your will and create an estate plan. You're talking about these things. So the attorney should be asking you about your family tree. They should be asking you what assets you have. Do those assets have beneficiaries? Do they have joint owners? Because it all makes sense, because you have to play out what's going to happen when you're gone, and this whole plan is going to come into play. If you don't have a will, there's a similar process to probate called administration, and the difference is that rather than in a will, where even after we go through this whole crazy process of finding who the next of kin are, giving them notice, and putting everything through probate, everything will go to the Hampton Bays Library because that's who you named in your will. In administration, there's a hierarchy of next of kin that actually receive your assets. So I had someone who said to me, I have two sisters. They are my legal next of kin. I love one very much. I would want her to get everything. And the other, I am not close with. We don't talk. We had a falling out. It would be the worst thing that could happen would be if she got some of my assets. And I said, well, then you better not just name beneficiary designations and not just say how you want the assets distributed, but you need to sign a will that says that all of your assets go to the one sister, so that your second sister does not receive anything upon your death in case there's an asset that doesn't have a joint owner or a beneficiary. All of this, as difficult as it's been over time, has been exacerbated by COVID-19. We had a shutdown of the courts, right away in March, of the surrogates courts, which are the courts in New York State that deal with death and wills and trusts after death. And the courts shut down. And then when they reopened, there's a lag, a very large backup. And on top of it, certain courts aren't issuing citations. So if you don't get one of those next of kin to sign and have notarized a waiver, then the court's not taking the next step to issue the citation to move the file along, and files are just sitting. And some next of kin don't sign the waiver because they don't want to and they want to be difficult. Others don't sign it because they don't have access to a notary, or because it's COVID, they're not going out of their house, and so they don't have the ability to go to a notary. And so there's a lot of reasons always why we wanted to avoid probate. But now with this situation with COVID-19 and us seeing how something like this can create a court shutdown, we're telling more and more people that they should be trying to avoid probate. So how do you avoid probate? Well, I spoke about having joint owners on accounts or beneficiaries named on accounts, and those are both valid ways to avoid probate. The other way to avoid probate is to create a trust. Very often, if the only goal of the client is to avoid probate, we have them create a revocable trust. This is a trust where if I create it and I put my assets in it while I'm alive, I can be the trustee, I'm in charge of the assets, I do whatever I want. But then that trust document says what happens with those assets upon my death. That trust document also says what happens if I'm incapacitated. Maybe I want my assets to be able to be used for the benefit of my spouse and my children if I'm incapacitated. Maybe I'm nervous there won't be enough for me, so I actually say in the trust that the money in the trust can only be used for me if I'm incapacitated and can only go to them after my death. You can put all of that in the trust document. And then the trust will take ownership of things. So for example, if you own your home, you can sign a deed giving your home away to your trust. Now you are just really giving your home to yourself, but remember I said probate is for assets that are in your sole name with no beneficiary. If the house is in the name of the trust, they're not in your sole name, and therefore it avoids probate. So a revocable trust can be a really important tool to put all the assets under one umbrella. I referred before to people might want to avoid probate and but might want assets to pay into their estate if they might owe taxes. If somebody is going to owe estate taxes, we want to make sure that the executor or the trustee of the trust has access to the funds to pay those estate taxes. And so very often we want the beneficiary of the accounts or the owner of all the accounts to be the trust, so that the trustee can pay all the debts and expenses as necessary, including taxes, before distributing the assets out to the various individuals or entities that are beneficiaries. So you put it under one person's control rather than beneficiaries going to bank accounts with death certificates and just claiming their assets, and then there isn't money available to pay your final debts and expenses. Some people also need a trust for other reasons. We're going to talk a little bit about Medicaid eligibility today, and a lot of people use trust planning to protect assets for Medicaid purposes. So Medicaid is a health insurance program that gives long-term care services to those who need them. So most often our clients who are applying for Medicaid long-term care services are those who are perhaps over 65 years old. Medicare is their primary beneficiary. It stays their primary beneficiary, but they want to apply for Medicaid to cover the costs of long-term care, because having a home health aide in their home or the cost of long-term nursing home care is not covered by your Medicare or other insurance or by a Medigap policy. And so for those individuals that want to apply for Medicaid to cover the cost of long-term care, they will need to qualify on a financial level. And so many people will take their home or some of their other assets and move them into an irrevocable trust, IRREV, irrevocable, and then be able to use those assets, be able to save those assets to be passed on, and they will not have access to them. So say an individual needs Medicaid, they will put their home, let's say, into a trust, and maybe they have $100,000 in a brokerage account. That $100,000 brokerage account goes into the trust, but then the principal of that account, the $100,000, cannot be used for the benefit of the original owner, of the Medicaid applicant. So you have to leave that money in the trust and leave it intact. Now, if that $100,000 is invested and it's creating income, interest and dividends, as the original owner and as the creator of the trust, I can get that income, and Medicaid's okay with that, but I can't access the principal. So that's what people use an irrevocable trust for Medicaid purposes for. Now, there's many types of irrevocable trusts, but we're not going to go into all the different types today. We're mostly just going to be talking about this Medicaid Asset Protection Trust when I talk about irrevocable trusts. Just to backpedal on the Medicaid context, this year's numbers, if you are a single person applying for Medicaid for long-term care, you need to have less than $15,900. It's only January 14th. I don't have the numbers memorized yet. $15,900 in your name. That means if you have more than that, you do not qualify for Medicaid long-term care services. You are allowed to have $904 worth of income per month. And we're going to talk in a minute about how to protect your income above the $904, but that is this year's number. Another thing that's important to know about Medicaid is everybody's heard about the 5-year look back. So if somebody wants to apply for Medicaid to pay for long-term care in a nursing facility, Medicaid is going to look back at 5 years of your financial life and see if you gave money away during those 5 years, and then that would subsequently create a Medicaid penalty. Giving money away could be giving money to a charity, giving money to your children, giving money to a trust, like I'm talking about. And on Long Island, for every $13,834 that you give away, that's a 1-month penalty. So if in 5 years I gave away $27,000, that's going to be roughly a 2-month penalty. So that means that for the first 2 months that I need Medicaid to cover my care, they're not going to cover it. And I'm going to have to privately cover the cost of that care. Now, the cost of care in a long-term care facility on Long Island is almost always over the $13,834 number. So you can think of it as for every 13 and change you give away, you end up paying maybe about $815 or $18 or maybe more for a nursing facility for that penalty period. So what we like people to do is do as much advanced planning as possible to transfer assets out of their name if that's what they're choosing to do, so that 5 years goes. Now, if we were having the same conversation a year ago, I would tell you that the good news is there's no look back for home care Medicaid. That's no longer the case. The law changed, and in April, it was signed and as part of the budget that was signed by the governor in April, that there is going to be a 2.5-year look back for home care Medicaid services. Now, this was supposed to be implemented on October 1st. However, because of the COVID emergency and the state of emergency as determined by the federal government, the implementation of this in New York State has been delayed. The current information that we have is that this will be applied for applications after April 1st. It's possible that will be pushed back again, although we don't have anything definitive saying that yet. So stay tuned and we'll put out more information as that changes. So if you apply for Medicaid right now for home care services before April 1st, they're not going to go back 2.5 years and see if you transferred assets. However, if you apply in May or in April for home care services, they are going to go back and they're going to see if you transferred assets to create a penalty. Now, if you're someone who did advanced planning several years ago, you're not going to have to worry about that 2.5-year look back because they will only go back to October 1st. So it's not a true 2.5 years until 2.5 years after October 1st, which I think gets us to June of 2023, I believe it is. So if you were to apply on April 15th for home care services, and there's a look back, they're going back from April 15th of 2021 to October 1st of 2020. And then it'll continually be an extra month until we get to the 2.5 years. So what does that mean? It really just means more of the same. It means that advanced planning is necessary. We don't have the ability to make these last minute flips of assets for home care services like we used to. Now, does that mean that somebody who did no advanced planning is totally out of luck and has to spend every dime? No, it doesn't mean that, and it didn't before for nursing home care. There is usually last minute planning we can do. We have different tools we use, promissory note planning, special gifting, to allow some, if not all, of the assets to be protected. We can just save some of them as much as we possibly can by shifting around where the assets are and how to pay during that penalty period. And so if you're in a situation where you or a loved one needs care and you think, oh, we're out of luck, we didn't plan 5 years in advance, that's not true. You should see an elder law attorney to see if there's anything you can do to protect some of the assets. The last thing that I'm going to talk about is a pooled income trust, because I want to touch upon it, and I spoke about it a bit earlier. So for those individuals, which is many of our clients who have assets or who have income, above $904 a month. So say someone has Social Security, that right there might be above that amount. Social Security, a pension, and a distribution from an IRA, required a minimum distribution. Well, they would have all of those pieces of income would be added up. 904 of it would stay in their regular bank account with whatever bank they use. And the balance of their income would go to what's called a pooled income trust. This is a type of trust that's a supplemental needs trust that is used for people over 65 who are on government benefits so that they can keep the use of their income on a monthly basis, but also not be disqualified for benefits for having such high income. So take somebody with $2,000 worth of income. Approximately $1,100 of it will go to the pool trust every month. There'll be an administrative fee to the trust, but then that could be used to pay their rent, their mortgage, their maintenance, their food, their clothing, whatever it is that they need while they're on Medicaid for their other bills. It could pay, if Medicaid only covers 6 hours a day of care, it could cover another 4 hours a day of home health aid care, whatever the individual needs in order to have their bills be paid. And so the pooled income trust, we're very lucky to have it in New York because it allows people to stay home because they can keep paying all their bills with their income. One thing I will flag for you as a potential issue, now that we'll have a look back for home care Medicaid, is that it used to be that at the end of the month, if your assets have accumulated in the trust, that then it could just accumulate over to the next month, roll over to the next month, and it will be there for you until your death, at which time the charity who runs the trust would get the balance. We don't know if that will be the case with the new law, and so if you are a person who uses a pooled income trust or has a loved one who does or is thinking about applying for Medicaid, you're just going to want to pay attention as we get more and more information from the Department of Health as to how those pooled trust funds can be used and what happens if you have money left in the trust at the end of a given month that was not spent for your benefit. So I think at 40 minutes, that is our estate planning and Medicaid basics. I think anything further would go past the basics amount. I see some questions in the bottom on the screen here. I'm going to answer them. If I don't answer your question, it might be because it's a little complicated or detailed for this group or for the fact that we are a group. And so I might just ask that you reach out by email and ask your question. My email is bburner@burnerlaw.com. That's BBURNER @burnerlaw.com. Okay, so someone asked, what if you're single, no children, parents and siblings are older and not easily accessible? And I think this was back when I was talking about probate. So that's likely going to be a situation where you might want to avoid probate because you want to avoid your next of kin, which in this case are your parents and your siblings, having to sign off or be involved in the probate process. If that person has an additional question on that, you can feel free to follow up and ask it. Can the will go through short probate? So there is a process called a small estate administration. So if your probate assets are less than $50,000, you can go through a shorter process, although right now it's not that much shorter of a process. The only good news is it's a $1 filing fee. So, rather than on some estates where they get larger, just sliding scale of fees, it only has a $1 fee. Although if you think that there might be assets that are going to come from different places, it's not a good idea to do that. So you'll probably want to talk to an attorney to see what makes the most sense if the assets are less than 50,000, but it's not a much shorter in actuality process. The question is, can a power of attorney change a retirement account beneficiary assigned prior to incapacity? So it depends. First of all, it depends if the power of attorney document gives the agent under that document the power to change retirement account beneficiaries. If it does give that power, then the power is there. However, I will note that the agent under a power of attorney is required, and they sign it and have it notarized, where they say they will only do what is in the best interest and follow the stated testamentary intent of the principal of the person who created the power of attorney. So if somebody's doing something they shouldn't be doing, they have the power to do it, but that doesn't mean that they can or should do it. And there can be an action brought against them if they do something that's either against the stated wishes of the person who named them as power of attorney, or against the what the powers they had in the document. Who can you choose as an executor? You can choose anyone you would like. So some people go with a family member. Some people choose a good friend. Some people choose the person that they're naming as the main beneficiary because they think that's easier. We do have clients who choose our law firm to serve as executor, or some people have accountants or other advisors. Financial advisors usually cannot do so based on their own internal compliance rules. But there is not a limitation as to who you can choose, as long as they qualify in that they haven't been convicted of a felony and there's nothing else that they've done that would make them an attractive candidate as executor to the court or to the beneficiaries who have to sign off on it. So is it legal for Medicaid to take the overage when the person has no savings? Yes, Medicaid is entitled. If you have more than that $904 a month in income, and Medicaid, you don't put it in a pooled income trust, which many people don't when it's a small overage because they don't think it's worth it, then that money has to be turned over to Medicaid, regardless of whether or not you have savings. Well, I thank you all for joining us this evening. It was a pleasure, and thank you again to the Hampton Bays Library. And there's Donna. Thank you, Donna. We also have other seminars and webinars that are from the past that are on our website, and also a list of upcoming. And so thank you so much for joining us, and thank you for having me tonight, Donna.
This was wonderful. Thank you so much. A lot of terrific information.